Good afternoon, everyone. I'd like to wish you a happy new year. My name is Kathy Purdy. I'm marketing manager here at Schoeneck King. I'd like to welcome you to this week's discussion and update on COVID-19 webinar. Two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will address those as time permits throughout today's program. Once the webinar has ended, if you would take a moment to complete the brief survey, we would greatly appreciate you doing so, as our attorneys do look at those and appreciate your suggestions for future topics. So without further ado, I'm going to hand it over to Pete Jones in our Syracuse office.
Thank you, Kathy, and good afternoon, everyone. As Kathy said, Happy New Year to everybody. I hope you're off to a good start, and here's hoping that 2021 is a great year for everyone. We're going to jump right in with Jeff Shear. Jeff was with us a couple weeks ago and talked about the relief package, what we're calling PPP2. Since then, it's become final, so Jeff will probably be reviewing some of the things that he said before and maybe offering some new insights as well. So Jeff, take it away.
Great, thanks Pete for having me on again, and it's good to see everybody. So as Pete said, I think a couple weeks ago I was on. We talked about the Stimulus Act, and I think I spoke rather quickly from what I heard from a few people. So what I wanted to do is slow it down a bit and talk about some of the highlights of PPP2 and what we can expect, and maybe some of the things that what we still don't know right now. And the fact of the matter is the Stimulus Act was passed 2 weeks ago. We of course expected some guidance to date, but we have not yet received some. So what I thought I'd do today is just give a bit of a slower overview of the program and of eligibility. So the first thing is that, and what's interesting is that the PPP2 has given us a second round of loans for entities that already borrowed and expended their first loan, but also for entities that didn't qualify, or not necessarily didn't qualify, but didn't get loans in the first round. There are additional expenses that are allowed to be used. I'll cover that just briefly. There's a simplified forgiveness process for loans that are under $150,000. And as I think a lot of people have read and heard about, the act reverses the IRS's position on the non-deductibility of expenses that are covered with PPP loan proceeds. So first about eligibility. The new round of funding is available to businesses that employ no more than 300 employees. This is a change from the first round where it was a 500 employee limit. What's not clear right now, and what we're looking at, is whether the SBA's alternative size standards apply to PPP2 eligibility. If you recall, on the first round, there were alternative size standards that applied, which allowed some borrowers with over 500 employees qualify for PPP1 round monies. And these size standards can be found on the SBA website, generally linked to annual revenue or number of employees. I've read a number of articles that said the alternative size standards do apply. I've also read the statute, which doesn't give an indication one way or another. But that 300 employee limit will affect some borrowers on this second round. The second thing I wanted to mention, and this is something that I've talked a lot about with people who've called me about eligibility, is the requirement that gross receipts for the first, second, third, or fourth quarter of 2020 have to be 25% less than the same quarter in 2019. Gross receipts for for-profit entities is the total amount that the organization received from all sources during its annual accounting period without backing out costs or expenses. So I think when you're looking at a for-profit organization, this is going to knock out a number of PPP1 eligible entities from participating in PPP2. One of the things I did want to mention on this call is the definition of gross receipts for nonprofit or tax-exempt entities. Unfortunately or fortunately, gross receipts for those entities is taken out of, or the definition is from section 6033 of the code. And it is a very broad definition as receipts from all business activities, contributions, gifts, grants, etc. So it's a very broad definition. And I think there are some exempt entities or not-for-profit entities that when they realized their receipts were going to be down in 2020, probably fundraised like they've never fundraised before, and may have attempted to make up the difference in what they were going to lose on other types of revenue, and may have partially made up what they were going to lose. Any of that fundraising is going to be included in the calculation of gross receipts for exempt entities. The third piece of eligibility is that businesses must have used or will use the full amount of the PPP1 loan. And that's really important because there are some late PPP1 borrowers who are probably still within their 24-week covered period and have not yet spent all their money. But so to qualify for PPP2, it's very important that you've used or will use your monies from PPP1. The good thing is that PPP2 extends well into 2021, which should give many people that, that opportunity. The loan calculation is very similar to PPP1, 2.5 times your average total monthly payment for payroll costs during the previous year. So that is, that's very similar. What's different is that PPP2 loans are capped at $2 million. So the idea here is when you look at the employee limit at 300 employees, loans capped at $2 million, the reduction in gross revenue of 25%, the SBA, the federal government is really looking at businesses that have been adversely affected by this pandemic. And I think that really hits home when you pull those three pieces together. So the other piece that I mentioned at the top of my my brief talk here is that there are other expenses that you can cover with PPP2 monies. Though there are 4 additional buckets in addition to payroll and mortgage, interest, and utilities. There are certain operational expenses. For example, the purchase of business software, cloud computing services that facilitates business operations. That's an allowable cost. The costs associated with property damage that's not covered by insurance, and that was a result of vandalism or looting during certain public disturbances in 2020 will be covered. There's a very broad category of covered supplier costs, which are expenses made by an entity to a supplier of goods, goods that are essential to the operations of the business. Again, it's a very broad definition, and I'm hoping for additional guidance on what exactly that means. And lastly, worker protection expenses, PPE, and not only PPE actually, but also expenses that you may have incurred to ensure proper social distancing, to allow, for example, a drive-through window at your place of business, to allow for an expansion of outdoor business space at your place of business. So these are some additional ways that you can spend the money once it is received. So in terms of when we can apply for PPP2 round, I really don't know yet. I'm not sure when the application period opens, when lenders will be issuing PPP2 funds. We're supposed to be getting some guidance within 10 days of the legislation. That 10-day period expires on Thursday, so we'll see what happens. I think your best bet is that if you're interested and you are eligible in accordance with the eligibility that I just mentioned, if that is the case, that you contact your banker and at least get on a list with them for these PPP2 funds. So that's my general, much slower overview. Hopefully you're able to pick up a little more than last time when I spoke like a mile a minute. And as new regulations come out, I'm sure I'll be back on the program to give some additional explanation. So I'll turn it back over to Pete. Thanks a lot.
Thanks, Jeff. I appreciate it. I just thought you were speaking fast last time because you had so much to pack in. So,
well, that was the case too. So, thanks.
all right, excellent. All right, so again, 2 weeks ago we had Stephanie Fedorka on. Stephanie was kind of reviewing the employment provisions in the relief legislation, and again, during the interim, we had a little bit of a concern that it may not actually go through, but it did. And so Stephanie's going to talk, as Jeff did, about the employment provisions and the things that are in the final package, and frankly, some of the questions we've been getting.
Thanks, Pete, and thank you all for joining me again. It's great to be on the program. Again, this is going to be a little bit of a refresher, a lot of material that we covered a couple weeks ago if you tuned in, and then a couple of common questions that we've been getting. So it was signed by the president on December 27th. Again, like Pete mentioned, a little bit of concern, but it did go through. Next slide, please. So the biggest question I think that we've been getting with respect to employment and employers is the FFCRA. So the paid sick, the FFCRA, a little bit of a recall refresh, applies to employers with less than 500 employees, private employers. Public employers weren't able to claim there was a tax credit component. The FFCRA required employers to provide certain paid sick and expanded family and medical leave for certain employees related to COVID-19 issues that we were seeing. So those benefits ended on December 31st, 2020. There is no extension. There is no more mandate. Employers are no longer required to provide those paid sick and extended family and medical leave benefits. However, next slide, please. There has been an extension of tax credits that are available for employers who voluntarily continue to provide FFCRA style leave under the framework. So effective, starting January 1, 2021, I'm sorry, that's a typo, covered employers who voluntarily provide leave, continue to provide paid sick leave or EFMLA leave under the FFCRA framework may be able to take advantage, or they may take advantage of the tax credit that is available. So, what does that mean? Again, FFCRA leave is not mandated, is not required. Employers can choose to voluntarily offer the benefits under the framework, and they can reap the tax credit through March 31st of 2021. So that's the first quarter. This does not renew the entitlement or allotment. So employees who have previously taken FFCRA leave, even if the employer decides voluntarily to extend leave benefits, if an employee has already exhausted their allotment under the FFCRA, that's it for that particular employee. Employers cannot take advantage of any claim tax credit for anything beyond what the FFCRA leave provided initially. Next slide, please. The Department of Labor did issue some FAQs a few days ago. I don't particularly think that they're super enlightening or helpful, but we'll go through them. So FAQ number 104, it's under their FFCRA section. I was eligible for leave under the FFCRA in 2020, but I did not use any leave. Am I still entitled to take paid sick or expanded family and medical leave after December 31st, 2020? So again, not super helpful. I say that because it just says employers are not required to provide the FFCRA leave after December 31st. And then the DOL actually refers employers to the IRS webpage for questions about claiming the refundable tax credits, which we will get to. It has not been updated as of yet to reflect the most recent stimulus act. Next slide, please. FAQ number 105. I used 6 weeks of FFCRA leave between April 1st, 2020 and December 31st, 2020 because my childcare provider was unavailable due to COVID-19. My employer allowed me to take time off, but did not pay me for my last 2 weeks of FFCRA leave. Is my employer required to pay me for my last 2 weeks if the FFCRA has expired? So the answer to this is yes, and that's because the wage and hour division at DOL, the US DOL, will continue to enforce FFCRA for leave taken or requested during the effective period, which is April 1st through December 31st. So the complaints just have to be made within the statute of limitations, which the DOL puts in the response as well, that the statute of limitations for both the paid sick leave provisions and the EFMLA provisions, 2 years from the date of the alleged violation. So whether that was a denial of the leave, or 3 years for cases involving alleged willful violations. The employer willfully did not comply with the requirements under the FFCRA. So again, this is not super helpful. It just establishes that just because the expiration period has the FFCRA has expired, the leave provisions doesn't mean that the Department of Labor isn't going to enforce violations that happen during that period. Next slide, please. Some of the most common questions that we've been receiving: can employers choose how long to offer the FFCRA style leave between January 1st and March 31st? In other words, can we say, oh, we only want to offer it through February, for the month of January, versus offering the FFCRA style leave through the entire first quarter and receive the tax credit? The language in the statute is unclear. Again, I think guidance, we're waiting guidance from the IRS. I think they will issue something. It might take a little bit of time just because there's so much new stuff in the act that the IRS has to address. Can employers pick and choose to only offer paid sick leave and not EFMLA leave, or vice versa, and still claim the tax credit? Again, I think the statute is unclear as written, perhaps, but awaiting guidance, further guidance from the IRS. We will be monitoring that. I will be personally checking the IRS website to see, if and when any additional guidance shows up and is posted. So stay tuned, and I will be sure to update, either through a blog post or on the programming as we get that information, because these are the most common questions we have received. So what's the risk? I think here is the follow-up question to that, right? I think one of the biggest risks is you offer the leave not you don't offer the leave for the full period of time from January 1st through March 31st. You only offer part of it. You only offer the paid sick leave provision, not the EFMLA. And then the IRS says you don't qualify, you can't claim the tax credit. Another risk, perhaps, is the potential for discrimination claims. We want to avoid arbitrary selection of who can take the leave, when, for how long. So if you're going to choose to extend these FFCRA benefits, again, enforcing a consistent policy, making sure it's clearly articulated to avoid those potential discrimination claims. Next, briefly, unemployment insurance. Again, there was a $300 federal benefit supplement, which is half of what was previously provided, the $600 earlier in 2020. And then it also extends the UI benefits for an additional 11 weeks. So the time in the act is from December 26, 2020 through March 14th, 2021. Apologize for the typo there. Certain provisions that allow for certain benefits to continue through April 5th, 2021, if an individual has not already exhausted their maximum benefit amount. Next slide, please. And then these are a couple other provisions. They're mostly tax provisions, so I would encourage you to talk to your consultant, your tax advisor, tax attorney, tax consultant, whoever you rely on for that professional advice. There are a lot of other tax provisions that are available for employers, like the business meals that you might have heard about that are now a deductible expense, employer paid student loans, qualified disaster employee retention credit, which was extended and it also was increased. And then there's also provision on paid family and medical leave credit available for employers who provide it. It's separate from the FFCRA tax credit, but that was also extended as well through December of 2025. So encourage you to consult with your tax advisor, tax professional, if you have questions about eligibility for these available tax provisions in relief in this bill. I think
Stephanie,
that's
thank you. Appreciate the update. Teresa is going to talk to us at the end at some of the leave implications and trying to put this all together. But in the meantime, we're going to now turn to Katie Anderson. Katie's going to update us on what's happening in Albany, and there's still a lot happening. Go ahead, Katie.
There is still a lot happening. And in fact, I have additional updates. The governor is currently speaking, so I have some updates from that as well. Let's start first with the vaccine. The vaccine, New York has distributed just about 900,000 and has administered 275,000 doses, just about, which is 31% of what's been distributed to the state. That's a problem, obviously, and that has really irked the governor. That has come to fruition now in a few executive orders that I'm going to discuss in a little bit. But yesterday we saw a press conference where he went over the chart of the highest performing hospital systems and the lowest performing hospital systems in terms of dosages administered. Today, the governor announced that they are working on setting up COVID vaccination drive-thrus at SUNY and CUNY campuses, do at churches, at the Javits Center. I suspect that it'll be also, maybe other centers like that. Any place with a big enough parking lot may be set up to be a vaccination center. One thing to note here too is New York has about 2.1 million people that are in phase 1A of the vaccine distribution plan. Phase 1A includes healthcare workers generally. And so there's 2.1 million. We have yet, we're almost at receiving half of those, but they haven't been administered yet. Looking to phase 1B, just preemptively, phase 1B will be people who are 75 and older and essential workers. So they're really working on, or trying to at least work on plans for distributing those vaccines. Executive Order 202.86 came out last week. This requires that when you receive a vaccine as an individual, you have to fill out an attestation form that says that you are a member of a priority group that may receive the vaccine. So that group 1A I just discussed, or 1B. If you don't fill out that form, there can be significant consequences for the healthcare provider. The healthcare provider may be fined up to $1 million per dose or have their license revoked if one, a person doesn't fill out that attestation form, or two, the healthcare provider administering the vaccine knows that that person is not eligible to receive the vaccine at that point. So if I, for example, with just being who I am, walked in to get a vaccine today, that healthcare provider could face some really steep consequences for giving me the vaccine. One thing here, this is really to prevent line jumping. In Florida, you've had lines of people waiting to get this vaccine. It's become a very hot commodity, and this is to really slap down on that and to prevent that. Meanwhile, the next executive order is all about administering the vaccine and how quickly healthcare providers must administer the vaccine. This executive order was issued this morning. It says that every healthcare facility receiving vaccines must administer all doses received within 1 week of receiving them. So you have 100 doses, you have to administer all 100 of those doses within 1 week. This applies to vaccines on hand at healthcare facilities as of January 4th. They must be administered by January 8th. This carries its own set of fines. It says that the penalty may be up to $100,000 and/or elimination or reduction of future allocations. It's also enforceable by Public Health Law Section 12, This may lead to additional fines. One thing to note, the healthcare facilities have to continually be in contact with the Department of Health. If by the 5th day of receiving the vaccines, they don't think that they're going to be able to administer all of them, they need to contact DOH and let them know, the Department of Health, and let them know that they cannot or will not be able to administer all of these vaccines. This is because of that 31% number I showed you in the beginning. We've only administered about 31% of the doses that have been distributed in New York State. The biggest breaking news as of yesterday, and it continues, this is only going to get bigger and bigger of an issue in the United States and in New York, will be this more contagious, we're calling it the United Kingdom strain. Just call it one of the strains that's currently developing. There's also a strain that has been found in South Africa. So the more that this virus is spreading, the more it's going to mutate, which makes vaccines all the more important to eliminate or try to eliminate the number of people who are getting the virus. But this UK strain was found, identified yesterday. A 6-year-old in Saratoga Springs, working in a jewelry store, was identified as having this strain. It is unclear who it came from, but obviously it came from community spread since he did not travel anywhere beforehand. There are 3 other cases in the jewelry store. It's unclear if they're the new strain because you have to test specifically for this new strain. Albany does have the capability to test for this new strain, but generally, your rapid test or your PCR test will not be able to test for it or tell you that it's specifically this new strain. It's 70% more contagious, which is a huge issue, and it's really underlines the importance of masks. And I suspect we are going to see some changing guidelines in the upcoming days and or weeks about wearing masks, even if you are 6 feet apart. I suspect that's going to be coming up. It's important, and I know I do the Albany update, but I'm going to look really quickly at the United Kingdom. The United Kingdom ordered a 6-week shutdown yesterday. I put this graphic in here, it's from the BBC, and you'll notice that I put a nice little arrow in there that I drew. The cases in the United Kingdom were going down in November, and then this strain was identified, and you can see what happened. Things exploded, and it's not necessarily just the holidays, which is part of the reason for the thinking of the current state of New York's curve. New York's curve, if we could have the next slide, please. If you look at New York's curve, you see a steep increase. Experts are now debating or discussing the fact that this increase may not just be limited to the holiday season. It may be because this strain has been floating around New York for at least 2 weeks. So that is obviously very concerning. I'm sure my update next week will be very different, but this will be the newest hot topic. It's not going away. I hate to end on a grim note, but it is, it's pretty grim. So with that, Pete, I will pass it off to you.
And Katie, just to maybe, before we move on and to maybe temper the grimness, just a hair, my understanding is that the measures that we've been talking about are still recommended, the social distancing and the masks with respect to the new strain, and that the experts believe, they don't know for sure, but believe that the vaccine should be effective as well.
That's correct. I would expect that we're going, just based on the research I've seen on this new strain, there may be some changes as to what's considered social distancing, just because it is so much more contagious, and COVID-19 is already an extremely contagious, disease. So it doesn't appear to transfer in a different way. It appears to be limited to, the same aerosol type of transfer that exists currently. But again, that the vaccine does appear to continue to work with it, which makes the all importance of vaccinating as many people as possible even more important now that we have this more contagious strain.
Great. Okay. Thank you. We're going to turn now to Adam. And there have been some updates on quarantining, and it's also the quarantine rules. And I think it's also useful to review to some extent the old rules and how they may be impacted by the updates. So Adam is going to take us through that.
Pete, thank you very much, and Happy New Year to everybody watching the webinar today. So we wanted to go over some recent changes in the New York State quarantine requirements that came out during the holiday week. Unfortunately, these changes have caused more confusion, which the state guidelines tend to do sometimes. So we wanted to walk through what the changes are and how they may impact you as a business. So before we do that, I think it's important to draw some distinctions. First, the question is, what is a quarantine? And really the way that we all have been using the word quarantine is going to mean something different depending on the context in which you're using it. So for example, the State Department of Health talks about quarantine and isolation as a very specific thing. They have documented guidance that talks about what is required when someone is actually in quarantine or isolation. So for example, someone in quarantine is not supposed to be in public or otherwise leave their quarters. If they're in a family, they have to have separate quarters, separate access to a bathroom. Their food should be delivered to them. And there are all these very specific precautions for someone who's in quarantine. This differs from what we use in our business when we talk about someone returning to work. Oh, well, they're in quarantine, so they can come out of quarantine when they come back, when they can come back to work. That's a very different discussion, return to work versus actual quarantine mandated by the Department of Health. So I think it's important to draw that distinction. If we look at the travel guidance, for example, the travel guidance talks about an actual quarantine. So someone who travels to a non-contiguous state or who travels to a level 2 or higher international country is going to be required to quarantine, that formal quarantine when they return. So with that context, I want to dip into what is new. So in early December, I think it was December 2nd, the CDC came out with some revised guidelines regarding quarantine for individuals who are exposed to COVID-19. The revised CDC guidelines said that quarantines didn't have to be 14 days, but they could be reduced to 10 days. The CDC guidelines also had information about testing out of quarantine, but that's not relevant for our discussion. After the CDC guidance came out, I had, and I know that a lot of attorneys here had clients calling and saying, okay, the CDC reduced its quarantine requirement. Can we do that as well? And at that point, the answer was no. The CDC, while providing guidance, was not controlling here in New York. We were bound by the Department of Health's guidance. And at that point, the Department of Health hadn't reduced any quarantine requirements. On December 26th, the Department of Health did, in fact, put out a document revising its quarantine recommendations for individuals who were exposed to COVID-19. So I just want to go through what that new guidance said. So it required individuals who were exposed to, or I should say it allowed individuals who were exposed to, and that's the phrase that was used in the document, exposed to. And the way I'm reading that in the non-healthcare context is the same as someone who's had close contact. So the state had previously defined close contact as someone who spent more than 10 minutes with an individual who tests positive within 6 feet of that person within 48 hours of when they become symptomatic or test positive. So the state said that anyone who had that close contact can reduce their quarantine from 14 to 10 days, so long as they remain asymptomatic, they continue monitoring their symptoms through day 14, and they receive counseling to continue non-pharmaceutical interventions through day 14. So the important part of that is that if an individual has close contact, with someone who's tested positive, they can come out of quarantine after day 10 rather than day 14. This guidance document also said that this reduction in quarantine requirement applied to individuals who traveled to a non-contiguous state or to a level 2 or level 3 country that did not test out or use that optional test out procedure that the state talked about in the travel guidance. This document also added an additional note that if you were a healthcare provider who worked in a nursing home or an adult care facility, that even though you could come out of quarantine after day 10, you couldn't go back to work until after day 14. At the same time that the state put out this December 26th quarantine requirement reduction document, it also put out a specific document for healthcare providers and when they can return to work. So the healthcare provider return to work document really just mirrors the quarantine reduction document. And it said that healthcare providers who had close contact, or it said who were exposed to a COVID positive individual could come out of quarantine after day 10 rather than day 14. So the state released those two documents. We have a reduction in quarantine requirements, and we have a reduction in the return to work requirement for healthcare providers. So that leads to the question that a lot of clients have been asking. I'm not a healthcare provider, but does this document now mean that I can allow my employees to return to work after 10 days if they're a close contact of a positive case and they remain asymptomatic? The answer is probably, but we can't give you 100% certainty, and I'll explain why. The guidance document that came out on December 26th says that it supersedes all prior guidance on quarantine requirements. So that can be read to imply that it also applies to return to work quarantine guidance that we've received. If you remember, the return to work guidance came in the form of several different documents depending on the industry that you were in. The most generally applicable document was the May 31st guidance document that we've talked about ad nauseum on these coronavirus webinars. So we know that the guidance document from December 26th says that it superseded the prior documents. We also know that it specifically discusses the fact that healthcare providers in nursing homes can, although they can get out of quarantine after day 10, they can't go back to work until after day 14. So that leads us to believe that employees can now return to work if they're asymptomatic following a close contact with a positive individual after 10 days rather than 14 days. Now, there are a couple of things that imply that maybe that's not the case. First of all, the May 31st document that I mentioned, that return to work guidance document that's generally applicable, that hasn't been updated. Now, the state has done this before where they will release a new guidance document and fail to amend older guidance documents that have applicability in a particular situation. Now, the December 26th document does say that it supersedes prior guidance, so take that with a grain of salt. Also, the state did update the return to work guidance for healthcare providers, but they didn't update the generally applicable return to work guidance. So that tends to imply that maybe individuals cannot return to work after this 10 days expires. Now, I think that the answer is probably they can. So probably your employees who are subject to a quarantine due to close contact can start coming back after 10 days, but it's not entirely clear. So I think, Pete, I will end there. I know that I kind of abruptly ended there, but I think that's where we are. Probably you can start bringing employees back after 10 days, but it's not perfectly clear.
Yeah, and Adam, this reminds me, and we've had to give this advice, and I think it's good advice, but not particularly satisfying to give or receive. That, you know, what's the best reading and reconciliation of the guidances that are out there? If you think back to the ordinary process for promulgating, you know, regulations and guidance and statutes, they're typically subject to a long time frame where some of these nuances get ironed out and addressed in the drafting process. The nature of the pandemic has been that, time is of the essence. And so things get, promulgated quickly and put out fairly quickly. And there are some inconsistencies that are just difficult sometimes, or some potential inconsistencies that are difficult sometimes to resolve. So we're frustrated by it too. And we certainly recognize that it creates challenges. On the other hand, we've said it before, and I think it still remains good advice. Give us a call, let us walk through it, walk through your situation. We'll help you balance, the facts and the various guidances, and we'll come up with a good approach. So that's about all we can do. Okay, well, I'll get off my summary here and move on to our next substantive topic. And we've had some questions in the chat, Teresa, so I think this is going to be a welcome topic for people. But can you just take us through where we are with the various leaves? We've been through this many, many times, but it's complicated. And the turning of the new year has brought some changes for us as well.
Sure. So with the new leaves and the old leaves that are being renewed, there are some different interactions. So I'm going to talk through briefly the different types of leave that might apply when someone is subject to an order of quarantine or has a COVID-19 diagnosis. As Stephanie covered in her portion of the webinar, we do have an expansion of the FFCRA that is voluntary. So employers who are otherwise eligible for FFCRA can voluntarily extend it to their employees. As Stephanie said, that cannot be used twice. If you already have an employee who took the 80 hours of EPSL, you're not going to be able to let them take an additional 80 hours. They've already used it. There's nothing in the new legislation that provides that kind of expansion or extension of the leave. So that's the extension of the federal leave. I'm not going to talk more about that since Steph already covered it. But we do have another type of COVID-19 leave, and that is New York State COVID-19 leave. That's the one that we've had since pretty much the beginning of the pandemic in New York. That's the leave that provides for either 5 or 14 days of paid leave when an employee is subject to an order of quarantine by a federal or state agency. Usually in cases that we've seen, it's been the Department of Health issuing those orders of quarantine. Remember that this is something more than just an individual voluntarily deciding to isolate themselves, or even a doctor saying that they have to quarantine. This is really pursuant to a governmental order of quarantine that this leave would apply. I will say, quick side note for healthcare providers, they are deemed to be subject to an order of quarantine when they have a positive COVID-19 test, even if there is no formal order of quarantine attached to that. But for everyone else, there is an order of quarantine required, and that's what's going to trigger the 5 or 14 days of leave. Unlike the FFCRA, which was expired and then voluntarily extended, the New York COVID-19 leave does not expire. There is no expiration provision or end date in that legislation. It continues with us into 2021, and it is certainly something employers are going to need to continue to work with and understand and apply when it comes to their employees. Along with New York COVID-19 leave, we of course have New York paid sick leave, which started as of the first of the year. That is also going to come into play when an employee has COVID-19 or is caring for someone with a COVID-19 diagnosis. So you'll have that in the mix as well. Certainly, we also still have our usual paid family leave and disability leaves working together, as well as the Family Medical Leave Act. All those different leave laws are going to interact when it comes to someone with COVID-19 or someone taking care of someone with COVID-19. Generally speaking, and again, this is going to be facts and circumstances dependent. If you have an individual who is diagnosed with COVID-19 and or has symptoms of COVID-19 and is subject to an order of quarantine, you would apply the New York State COVID-19 leave and or the FFCRA if you are voluntarily expanding that. Before you would apply New York State paid sick leave, there is language in the New York paid sick leave guidance that says the New York COVID-19 leave is meant to be separate from and additional to the New York paid sick leave, which suggests to us that those two leaves could not run concurrently. So what you would likely do in that situation is if you were expanding the FFCRA leave into 2021, you'd apply that first, then you'd apply the New York State COVID-19 leave, and then you'd finally apply paid sick leave, and you'd kind of go in that order. But again, that's going to be somewhat facts and circumstances dependent. So we encourage you to reach out to us if you're dealing with any of those tricky leave scenarios. And Pete, I think that's all the time I have, so I'm going to turn it back to you.
Okay, Teresa, thanks. Just one thing to make very clear, because some people may still be a little bit confused by it. The FFCRA, the legal requirement has expired December 31, 2020. And when you speak, Teresa, I'll have you back in here on the voluntariness. That is, something that you may choose to do. You don't have to do. And if you do it, then you're going to get into some of these issues that Stephanie highlighted for us in terms of, the deductibility of those expenses. Is that a fair summary?
That's correct, Pete. It's voluntary. If you want to continue it, you do not have to. And certainly if you want to continue with the FFCRA, you're now going to have to continue to deal with it interacting with New York State COVID-19 leave and learn how it interacts with New York paid sick leave.
Excellent. Okay. Well, thank you very much. That's really all we have for today. We appreciate everyone being with us. Once again, Happy New Year. We'll be back at it again next Tuesday. And everybody, please stay safe out there.